Hi everyone, thank you for watching Hamara Kanun. This is the English version of this week's video and we are talking about bail, the right to bail in India. Is there a right? What do we mean by bail? Now before we get straight into the law, let me just put a statistic out there. National Crime Records Bureau has reported that out of quarter to 3 lakh people who are put behind bars every year, around 2/3 of them take 3 months or more to get bail. So what do we mean by bail? Now legally bail is not defined anywhere, but what we understand bail is a security for the release of a prisoner, ensuring that the person appears before the court on the next fixed date. So once you have been, once there is a criminal charge against you of any kind, they can be either bailable, you could be charged either for bailable offences or you could be charged for non-bailable offences. Those are the two different kinds of offences that have been demarcated under the Criminal Procedure Code. Now, if you've been brought to book under a bailable offence, then as a matter of right under section 436 of Criminal Procedure Code, you can go before the court and ask for bail, meaning ask to be released by the court, promising the court that you're going to appear before the court on the next date of your matter. The court will not necessarily look into a lot of things. The court will see, fine, you have a case, it's a bailable offence and will release you as a matter of right. No discretion is involved there of the court. However, if you've been brought to book under a non-bailable offence, then you can approach the court either under section 437 or section 439 of Criminal Procedure Code, which are specifically for non-bailable offences. Now, since the term says non-bailable, you're wondering how will then a bail be granted? Now, in these cases, the court will look into the facts of each case to determine whether or not you should be granted bail. What is the difference between these two sections, section 437 and section 439? Under section 439, you can approach only a sessions court or a high court. So as a matter of strategy, what lawyers do is that they usually file your bail application before a smaller or a lower court under section 437. And if that court denies your bail, then a matter is filed before under section 439, either before the sessions court or the high court. As a matter of practice, once your bail has been rejected by a lower court, it becomes relatively difficult for you to be granted bail by a higher court. Therefore, if you directly approach the court under section 439, which by the way you can, and if it is rejected, you don't really have a remedy. Which is why the safe thing to do is to go under section 437 and then under section 439 generally, not going into the specific facts of your case. So here, under section 437 or 439, the courts will look into some specific factors to determine whether bail should be granted to you. What are these factors, you may ask? Most importantly, the first thing the court will see is whether there is a prima facie case against you, meaning at the first sight, does it appear that you have committed the offence for which you have been brought to book? Secondly, what is the evidence that the police has against you? Third, is there any possibility of you tampering with the evidence or the witnesses once you're released on bail? Fourthly, what has been your history, your employment history, your antecedents? Do you have any criminal records? Have you been, been pronounced guilty of any similar offences earlier, so on and so forth? The court will primarily see, are you a person of good character? Do you have a good standing in society? And accordingly decide whether or not bail should be granted to you. Sometimes bail can also be claimed on the basis of medical grounds. For example, if you have a severe medical ailment and you cannot be in prison, that could be also a good ground for which court may consider granting you a bail. Now, under section 437 and section 439, you can approach the court once you've been put into prison. But we have another section under Criminal Procedure Code, section 438, which is for anticipatory bail. Now, anticipatory bail exists because in India we see that many a times your political rivals may want you behind the bars, even though when you've not committed a single crime. So if you're a person who for any reason apprehends that there will be a case brought against you by your political or other rivals, you can approach the court in advance. So nothing has happened, there is no FIR against you. You approach the court and say, I am so and so, I fear that there will be a case brought against me at a certain time and I don't want that should happen. I'm otherwise a person of good standing. Then the court can give you an anticipatory bail. What that means is that even if a case comes against you which has non-bailable offences in it, the police will not be in a position to put you behind the bars. So this is section 436, which is for bailable offences, section 437 and 439, which are for non-bailable offences, and section 438, which is for anticipatory bail. Finally, I want to draw your attention to section 436A, which was added in Criminal Procedure Code by an amendment. Now, in India, there are several under-trial prisoners, which means that your trial is yet not complete and you've already served a long time in prisons. The court, this particular provision says that if you've already served half or full punishment for which you were proclaimed guilty, for which you were brought to book in the first place, then you can approach the court under section 436A of the Criminal Procedure Code, and the court may release you on conditional bail. The idea is speedy justice in India. If it's an irony that even though you've not been pronounced guilty, you've already been in prison for more time than that you were required to for the crime that they say you have committed. Therefore, section 436A is an extremely relevant provision that we need to be using more in India, especially for the thousands and lakhs of under trials that are there across the country. I hope this video was useful for you, especially given the nature of crimes in India and how less aware we are of what we do when the police picks us up and puts us behind bar for any offences whatsoever. If you liked it, please share it on social media, on Facebook, Twitter, WhatsApp, so on and so forth. Thank you so much for watching. I'm Avani Bansal at Harvard Law School. Thank you.